The Gelber case shows you how that, like everything we've looked at so far in criminal law, the the jury plays an extraordinary role. That if the jury comes back and finds that this was self-defense, of course, that's the end of the story. But in a similar way, if the jury disbelieves that the defendant either was acting in self-defense or believed he was acting in self-defense, or that his belief was unreasonable, then that's also kind of going to be the end of the story, unless you have something really, really compelling for the appellate court. In the Fisher case, we did have something really compelling for the appellate court. All the testimony in the Fisher case suggested that or was consistent with the view that the defendant had, that he was attacked by a man who was armed. He was not armed. The defendant was not armed. He was responding to a gun attack, and did so successfully while being unarmed himself. The Fisher case was extraordinary. I mean, this was a very one-sided case, and it's amazing that the jury came to the decision that it did to find Fisher guilty of a crime. But in the Gelber case, the question there is whether the jury got it wrong when the defendant and the victim meet to discuss the quality of cocaine that that the victim has sold to the defendant, and the victim ends up dead with many knife wounds. That the testimony at trial by the experts doesn't give any real basis for the claim that the wounds we see on the body, and there certainly weren't any on the defendant, that were consistent with a claim of self-defense, even though there were multiple defensive wounds on the victim. So the interesting thing about Gelber is that it goes to show the extraordinary role of the jury and the relatively limited role of the appellate court, that only if it's completely unreasonable will the court reverse. And here the court says, look, we really even have nothing to go on. There's nothing that corroborates the story. The court did allude to the one case in which the judge had made a finding of self-defense in a different case, where the judge said that the defendant unreasonably believed that there was risk to life or limb, and that's why that defendant acted. And the appellate court reversed, saying, look, that was the defendant's belief and it was reasonable, unlike what the lower court had concluded. One of the interesting stories that comes out of that particular case, though, is that in some ways you may be better off with a judge than a jury. And that case highlights this. When a jury comes back with a verdict of guilty or not guilty, by definition, we'll never know, at least in a forum we can consider, whether why the jury came to the result that it did. When a trial judge is the finder of fact, there will be a set of findings of fact, and in the event of a conviction, that might actually provide a basis for a reversal. When you just have a jury verdict, then the facts have to be on their face, based on the testimony, completely unreasonable for a conviction, if you're going to have that conviction overturned on the basis of sufficiency of the evidence. But in the Gelber case, the court says you've really got nothing to go on here. There's nothing that suggests that this crime was a matter of self-defense. The jury hears the case because there was enough to, or the jury hears the instruction on self-defense because there was enough to give them that instruction. But there's nothing more than that. So again, we see the standard in play. If anything raises a possibility of self-defense, the Commonwealth, the prosecution, has to negate that claim beyond a reasonable doubt. But they do have to negate the claim. But then when the appellate court goes to consider it, all the inferences are taken in favor of the verdict below, and you've got to have a really compelling case to get this reversed. Fisher, as a matter of law, was a self-defense, successful self-defense claim. Those are kind of rare. Most of the time, these will come down to jury questions, and the jury's resolution of whether there was, in fact, a belief of imminent harm, serious bodily harm or death, and it's the reasonableness of that fear. Most of the time, the jury's conclusion on that matter is going to be the end of the story.